I am an attorney that I practice. I have an office in Easton and recently opened my office in Easton, and I have an office in New Bedford where I've been for quite some time. Before that I was in Boston. I do a lot of work with, not just with the families with special needs children, but also with elders and things along those lines. A lot of work in terms of getting access to health care and in terms of issues related to incapacity, whether they're younger or older, whatever those things might be. I've been doing this for maybe 17 or 18 years. I have 4 of my own children. I've been through the IEP process with 1 of my own children. I was a child advocate for 10 years where I represented abused and neglected children as a volunteer. Had a lot of IEP, talked a lot about IEP issues. I'm not going to talk about that tonight, but I like to have a lot of information in terms of that. And I'm happy to be able to be here and share the information with you. What happens a lot of times with people that I meet is I get when children are a lot older, and the parents are also older, and they haven't had the chance to plan in advance, and we're faced with housing issues, we're faced with funding issues, and we're faced with all of these things, and we're also faced with the fact that mom or dad is already, who's cared for this child for years, already in their own health is in crisis. So I'll talk to you a little bit about some of the things that we can do to minimize that, some of the things that you can do, and then I'll talk to you a little bit about trust, which I think are really quite key in making sure that your children are protected if the need be, and depending on what the programs might be. And I'll talk to you about Social Security a little bit, which is always fun. But and then I'll talk to you a little bit about mass health, and I'll talk about guardianship and conservatorship. So guardianship is for medical decisions, conservatorship is for financial decisions. So basically when your children reach 18, in the eyes of the law, they're legally competent and can make all their own decisions for themselves. Now I question that for any 18-year-old, but that is, in the eyes of the law, that is. So all of a sudden your ability to deal with healthcare professionals might be limited. Your ability to go to do their banking with them or for them might be limited, and that's where the guardianships and conservatorships would come in, okay? And I'll try not to talk all over the place, but I probably will, because that's how I think, and that's how I problem solve, and so that's probably how I'll end up doing it. The 2 big things, the guardianship and the conservatorship, both require a medical certificate saying that the person is not competent, not able to make their decision. You do not need it before age 18. Before age 18, you still are the guardian and you have the ability to make all the decisions for your children. Anyone over age 18, or if it's a sibling or anything like that, if it's not your own child, a natural or adopted, then you would have to have those in place. The problem that I see a lot of times is that the automatic thought, sometimes if there's especially if an agency is providing services, is the automatic thought is you have to have a guardianship. You have to have a conservatorship. And there's no thought to alternatives, less restrictive alternatives, okay? The less restrictive alternatives there is a healthcare proxy and a power of attorney, okay? So a healthcare proxy is where anybody over age 18, can appoint someone else to make their medical decisions for them if they can't make them themselves, all right? So really anybody over 18, no matter what, should have one of those. The other is a power of attorney, and that's where you appoint someone to make financial decisions for you. Usually it's effective immediately, but the idea is you only use it in the event of incapacity, all right? Oftentimes, that can be obtained for a lot of children. Even though their competence or their capacity might be somewhat limited, they still have the ability to recognize, for lack of a better term, who their family is, or the technical term sometimes is the objects of your bounty. And that has to do with your will and things. But that's kind of the process. That's kind of the standard. Like, do they know that you're their parent? Would they want you to make medical decisions for them? And are they willing to sign something saying that they would do that? Okay? And it's a legal standard, not a medical standard. So where a doctor might very well say that they're not competent, if a lawyer looks at it and says, no, I think they're competent enough to sign these papers, then you can do that first. And it's always worth trying first. Sometimes it's not worth it. Okay? Sometimes you can't do it. But it's always worth at least exploring. Because once you're into a guardianship, you're in it for life. The only way out of a guardianship is for the person to regain competence. And depending on the level of what their of functioning might be, that may never happen, okay? And in most cases, it doesn't. It might, the times that it does happen is when somebody's in a coma or something along those lines and they get better, okay? But you're in it for their life. So if at 18 and they live to be 80, they're under guardianship till they're 80, okay? So it's a very restrictive thing. And what that means when I say you're in it, it means that all decisions have to be approved, or major decisions have to be approved also by the probate court judge. So should your child have, and I hate to even, sometimes this stuff is so gloomy, I'm sorry, but you know, should they get sick and need some sort of extraordinary treatment, okay? Should they need to be treated with some sort of an antipsychotic medicine? Should they need something, I can't even think of the term off the top of my head. If you had cancer, tell me the terms. When you have the infusions, oh well, chemo, thank you. You have chemotherapy, you need surgery, all right? They need the gallbladder out. You have to get the permission from a probate court judge to do that. You as their parent and their guardian can't make that decision. The judge has to make it. Anything invasive has to be approved by the court. Okay? Even a medication? If it's an antipsychotic medication, yes. Okay? If it's not an antipsychotic, so if it's penicillin or Benadryl or something, no. But if it's an antipsychotic medication, you have to get the court. And that's what they called Rogers, because there was a case about Rogers, where they were treating someone with antipsychotic medications. And you know, the antipsychotic medications can have a lot of side effects, and that's the reasoning. And they'll actually be appointed their own attorney, and they may be appointed a Rogers monitor, and you have to go yearly to have that reapproved, okay? Very tedious. So if you cannot get into that system, because once you get into the system, you really can't get out of it, in most cases, all right? So the first step is, hey, can we do this? Is this an option? Can we at least think about a healthcare proxy? Can we think about a power of attorney? Can we try that first? And maybe you can. So don't just automatically think, oh, you got to have a guardianship, because you don't always, all right? Again, it's a legal standard. Now, if you need a guardianship, then you have to have the medical certificate saying that the person is not competent, legally is not medically competent, really. All right, and if a child, if a person has, if they are MR, or they have something that they've been disabled since prior to age 18, then you do what's called a clinical team report, and that's done by 3 professionals. All right, and those are hard to get if you're not already in with an agency, because it's a social worker, a doctor, and a psychologist, and they have to all agree that the person, the proposed person, who's the incapacitated person or the protected person or the child, has to be under the guidance of the court. All right. Now, can you have a problem with that? You can, because your child can pick you to make those decisions for you. But then if they're not going to cooperate when you're making those decisions for them, in other words, if they decide that they're going to be independent and they're going to make their own decisions, then yes, you might still have to resort to a guardianship. So they can pick you, they can name you as their agent, but again, they're deemed to be able to make those decisions until a doctor says they're not capable of doing that. And sometimes you can get the healthcare proxy signed, but then the problem is the child resists or something along those lines, and so then we end up in a guardianship anyway. But oftentimes, it doesn't happen that way. And sometimes it may not happen that way for many years, all right? Especially if they're comfortable, you've been making the decisions right along, and they don't even appreciate that things have changed, all right? So it's always worth trying to do that first, all right? Before you jump automatic to a guardianship, all right? And then once you do a guardianship, then of course that's another whole process. It's a probate court process. The thing that you want to do too, if you can, and the courts have gotten much better about this, is limited guardianships. So technically, if you have a full guardianship, so in other words, then that that child, so I'm going to just keep referring to child, but for any person, if you have a full guardianship, then all of their rights are removed. They don't even have the right to vote anymore, okay? So everything is taken away from them. And so you may want to limit it, and I strongly recommend that it be limited in most cases. Let them have, if they're able to manage some money, let them keep track of some of their bank accounts. Let them make some decisions on their own. And you, the family, the people that know them best, are going to know what decisions you're best to leave with the child. And that's a decision, and that gets crafted right into the court decree, okay? And the same thing with the conservatorship. It used to be that there was one. It was a guardianship of the person and the estate. Now it's a guardianship and a conservatorship, but you would craft it into the decree, all right? And that, in other words, you say he or she can maintain the bank accounts, he or she can deposit all their money and use it, because technically, if they're under a conservatorship or a guardianship, well, conservatorship when it comes to money now, and they go to the bank to deposit their check and sign it, the bank shouldn't be accepting it. And if they're trying to withdraw money from their own account, the bank shouldn't be letting them do that. Well, that's an unnecessary deprivation of a lot of people's independence, all right? So you want to be able to allow them to keep as much independence as possible, all right? And that's going to come from the family. The lawyer isn't going to know that. The judge isn't going to know that. You have to say, this is what I think my child could do, all right? So that's kind of the big things on the guardianships of the conservatorships. But again, until age 18, you don't really have to worry about it, and then at 18, you really need to start thinking about it. Now, sometimes the doctors are used to you, you kind of float through, and nobody really pushes you on it. You know, you've been seeing the same pediatrician or PCP forever, and you know, the day your kid hits 18, they don't say, oh no, we're not going to talk to you anymore. A lot of times there's some flexibility, but you know, you want to start thinking about those types of things, especially if your child wants to assert their own independence, and it may not be in their best interest to do that. Okay, so that's kind of the big things on the guardianships and the conservatorships. Okay, any other questions that you had specific that you can think of? Okay, go ahead.
So when you talk about having to go in front of a probate judge, so every time you wanted to make a decision about medicine and anything, you would have to go to court?
No, extraordinary. So if there was surgery, if there are treatments with antipsychotic medications, then that has to be reviewed annually, no matter what. Okay. So surgery, anything invasive. All right, anything that might be things, but no, to just go to the doctor and treat for ear infections or strep throat or things like that, no. You have that authority. If you wanted to admit them to a residential placement, you have to get court permission for that, okay? So anything that it restricts their liberties, I guess is the best way to put it, okay? And they treat extraordinary medical treatment as being a restriction, okay? And then, yes, you would have to go in and get permission. Now, go ahead.
So the form for guardianship that the pediatrician, social worker, and psychologist has to fill out, is that a social worker and psychologist from a clinical setting, or is that a school personnel?
Usually, in most situations, we get whoever we can get. Because for people that have been in the system, I hate to put it that way, but people that are older that have been in the system, they have a staff, they have people that they've worked with. But oftentimes, if you aren't with an agency yet and you haven't had a lot of services provided, then if we can use it, then we try to do it. Sometimes you have to go to a private clinician and pay for the report. But yeah, so we try to get it wherever we can, the most cost-effective way we can get it. Okay. I don't know if the school would allow it. I mean, you know, they have their own set of rules too, so I don't know if they're allowed to sign off on those types of things or not. But you know,
that situation had come up, and I wasn't sure if it was, you know, a matter of like, you know, how long you've known the student, or you know, what their credentials were.
Actually, they don't really care how long they've known. It's just that they have to have the right credentials. All right, but if you needed to go to a private psychologist to get it done, and that was the only time you saw that private psychologist, they would do it, and that's fine. They don't have to have a long-standing history. Is it better? Sure, because then they kind of know what the child, again, back to how much restriction you want to place on the child, how much independence you want to remove from them. And the more the people preparing the reports and the family interact, the more independence usually the child can keep. right? Because you know better than anybody, okay?
You keep saying an agency involved.
So like DMR or DDS, those are the typical ones that we would see, okay?
So if you're, like, if you went to the agency when your child was 2, but you've never talked to the agency, your child was accepted into, say, DBS or DMR, but you've never used that agency because there's no funding.
Go there first. Yes, so if they have an open case, so to speak, if it's still open, if they still know your child, in other words, there's a file there with your child, then I would go to them first.
When they turn 18, don't you have to reapply for adult services?
You probably do, but if they have something open, then at least they've got somebody there to help you get what you need in terms of the clinical team report.
I don't understand what you mean something open. Like,
Well,
when my child was 2, and I haven't, he's 10 now, and I haven't talked to them since he was 2 because there's no funding, there's no nothing. Why they don't know my child? I mean, they know him back when he was 2.
And in that case, they may or may not, but oftentimes they still have a file. His name is somewhere in their system. And if you contacted them, and the reality of it is, if you need a guardianship, then DDS and DMH are supposed to help you get that. You're not supposed to have to privately do that. The problem with it is they're so understaffed that you oftentimes, if you're going to get that, it might take you quite some time before that actually happens. But a lot of times it's about, so if you have gone to that agency and you've opened a case, so you've told them about your child, they've had your child's name, situation, whatever the child's situation is, and the child's need, and they're aware of that, then my first avenue to them, my first response to them is, look, this is somebody that you service. You might not have done it actively for the past 8 years, but you've serviced this person. You need to help us now because this child's approaching 18 and he needs a guardianship or she needs a guardianship. So that's always first, okay? And yeah, the funding is always an issue, okay? But you at least try. So, but if they've never, you can still do it even if you've never gotten services from them or you've never gone and tried to get services from them. You can still try it, but the reality of it is it may not happen quickly enough, okay? And you can do it by yourselves. You don't have to have a lawyer to do it. It's hard, it's not easy, but I will say that the courts are aware and they are cooperative in trying to help. So if you're in Bridgewater, you're going to be in Plymouth County. If you're in Raynham, you're going to be in Bristol County. And so what my suggestion to be is if you're faced with that, I mean, to do a guardianship and to pay an attorney to do it can get expensive. You can do it on your own. If you do that, my first thought is, first, the clerks will help you. So if you have to do that, they will help you. They're going to do what they can. They're overworked and understaffed too, but they're going to try. And then you can always go when they have lawyer of the day. And the lawyer of the day can try to help you there too. That's a pro bono service. And so like I do lawyer of the day, and people will come in and say, well, I just need help filling out the paperwork. They're not going to help you get the clinical team report, and they're not going to help you get the medical certificate. You're going to have to figure that one out on your own. But they'll at least help you with some of the court paperwork. All right? So there are opportunities that are out there. Legal Services does guardianship work, but again, they're underpaid, they're understaffed, and a lot of times they don't deal with it unless there's risk. So it might be somebody who's at risk, maybe an elder at risk, or a child at risk, or somebody who was going to be. If they didn't have it, their safety was going to be compromised. Okay, so there's not a lot out there for services for people, that. But you can try to do it on your own, and I would, it's not hard to do, but it does take a little bit of reading, and a little bit of the paperwork is what has to be key. But the judges are very compassionate, the clerks are very compassionate, and so they will try to help you as best they can. At least all the ones I've dealt with. Okay. So, but if you have services or you are eligible from services from DMR or DDS, then try them first too, all right? Again, you may not get there fast enough, but, so all that wrapped up in a nutshell. Try the least restrictive alternative first, healthcare proxy and a power of attorney, okay? Then beyond that, if you have to go for a guardianship or conservatorship, if the healthcare proxy and the power of attorney are not going to work, then you go for the next step, which is the guardianship for medical decisions, conservatorship for financial decisions. You can try to do that on your own using legal services, lawyer of the day, or just asking the clerks at the court for help. And most of the forms are available online nowadays. Okay? If the child has a disability from before age 18, you need a clinical team report. All right? If not, then it's a medical certificate. Then all of that gets filed, and then once you're in the system, that child remains under guardianship or conservatorship until they're deemed to be competent, which many times never happens. Okay? Beyond that too, even if you don't have that, so even if you're doing, as parents, you're doing your own estate plan, you can nominate a guardian in your own estate plan for your children. Okay? So you can pick the person who you would want to be the guardian and or the conservator of your child in your own will. And there is also a standby guardianship form that you could do now. Okay? But those are other things that you want to think about in terms of doing your own things, is that you might want to pick who you want it to be if you can't be that person anymore. Okay?
So if you didn't get your own personal guardianship for a child, but you named the guardian in your will and something should happen to you, then the grandparent takes guardianship. Does the grandparent have to go through all of those same things, even if you didn't have it when the parents were around?
If the child needs a guardianship, yes.
Okay.
Yes.
But if they didn't need
If the healthcare proxy and the power of attorney were still working, then yes, they do not have to do that.
Okay, they would just take over.
But they will just take over where you left off. But if there is a need for a guardianship, they're going to look to your nomination first. All right, it's going to be the other parent first. The other parent's always going to have superior rights to anybody you would nominate, even if you're not married anymore. Okay, then the natural or adopted parent will have the rights first. But you can name people in there. Go ahead.
If you have a guardianship, say I had one on my son and I passed, do I name someone to take my place?
Yes, you would.
And you wouldn't have to go through everything again.
Well, no, you still have to go through everything again. Because the court has to find that person is
so I don't know if
competent
that's
to
what
do
she
it.
was saying
Yeah.
or not.
Yeah.
but-
So even if you already have a guardianship in place, you still want to nominate your successor. Now, sometimes the way around that is to name co-guardians, so you have more than one person. So if it's a husband and a wife and you're both the parents of the child, then the better thing is to have both people on there from the beginning. Because then that way if something happens to the other one, you don't have to worry about it. So you only have to worry about it if both people are gone. Or if it's going to be, you and if there's another sibling or a grandparent or something, go ahead and do it from the beginning. Just know that if you have two guardians, they have to agree on decisions. Okay, so that's the thing. All right. So, but once, that's they're trying to make it better, but you have to do the whole process all over again because the court has to approve the guardian. The child has to be protected, even if the child's 50. The child still has to be protected. So, so those are the issues with guardianship and conservatorship. All right, questions about that, beyond that?
Regarding healthcare proxies, so if I'm a healthcare proxy for my daughter, and she agrees that she's going to have the procedure done, say dental implants, go to the office, and she turns around and says, no, I don't want to do this.
Okay. So the way that works, so if you are the healthcare agent, you're the nominated healthcare agent, but nobody has what we call invoked the healthcare proxy. So she's still legally competent, okay? And the healthcare proxy is kind of laying in wait, which is a little bit different than the power of attorney, but it's laying in wait. And she says, I don't want the dental implants. Then she doesn't have to have them. If the healthcare proxy is invoked, in other words, so she signed one at 18, and she's now 30, and the doctors have said, well, we don't think she can she can't make a decision. She's not competent to make a complex medical decision. And they've invoked that healthcare proxy. Then, if she says no, then it gets even more complicated. But if she says no, then you have the authority to say yes, but then if she's strenuous in her no, then you have to go to court to say to the judge, she says no, I say yes, the doctors have deemed she's incompetent, and they have to do what's called affirming the healthcare proxy. Okay? So it's not simple. But it's better than it was because they didn't used to allow you to affirm the healthcare proxy. You just automatically had to go to guardianship. It's much easier to affirm the healthcare proxy, and once you do that, you're good. So she can always revoke it, even if she's incompetent. But then you just go into court and say, well, she's not competent to revoke it because it's been invoked, because she's no longer competent. All right? So that's why I say sometimes you start with the healthcare proxy and the power of attorney, but sometimes you really just have to do the guardianship because the child's going to make the decision that they want to make. And absent your being the legally appointed guardian, you're not going to be able to make those decisions without a lot more problems. But sometimes it works. A lot of times it does work. Okay? And, you know, a lot of times you go in, you have the healthcare proxy, even though it's not technically invoked, the doctors know that you're the agent, they know you're the parent, they've known you, they talk to you about the decisions. And the doctors feel much more comfortable knowing that the healthcare proxy is there, so that if something critical does happen, they know that they have somebody appointed to make those decisions quickly. Because the guardianship process is also not quick. It takes a while to get appointed. Unless there's an emergency, and then you can do a temporary guardianship, which lasts for 90 days. And that you can get immediately. But that, again, you still need the medical certificate and the clinical team report. Okay?
So how does the healthcare proxy get invoked? Is that through the...
So a physician would say that the person is not competent to make complex medical decisions. Yes. Yeah. It has to be done by a physician. That piece does.
And if we start the process with the healthcare proxy and the power of attorney, and then later down the road, I would have some people in my will or trust to take over as guardianship at the point where
yes. So you would nominate. So you in your own documents would nominate the guardian, so that if a guardianship was ever needed, that nomination is in there. But you can also name alternates in the healthcare proxy. So you can say me, my wife, my mother-in-law, you know, my daughter, my siblings, whatever. So you don't have to just leave it at one. And again, the healthcare proxy is the child's document, so they have to agree. So if they say, I don't want my sister to make those decisions for me, then that's it. We have to abide by that. But generally speaking, for most, especially where there's a high enough functioning that there's some appreciation, they're going to agree. They're going to look to you and say, what do you think I should do? And you're going to give them guidance. So, but it's ultimately their decision. You know, I mean, I had a client once who didn't want his sister to do it because she always stole his French fries when he was young. So he was like, she's not going to help me because if I'm in the hospital, she'll be taking my French fries. I was like, okay, all right, if that's what you want, you know. But that was his thought process. Was like, if I'm sick in the hospital, she's going to be taking my food. So I was like, okay. So but sometimes that's the processing. So that's what, and I can't do it then. I mean, could she be a guardian? Yes. But I can't create a healthcare proxy for him. In his case, I couldn't because he didn't want his sister to do it. So anyway, so that's healthcare proxy, power of attorney, guardianship, conservatorship. All right. Questions? Any more questions? All right. Social Security. I'll talk a little bit about that. Equally, none of it is easy, and it doesn't ever get easy. And it just doesn't ever get easy. Social Security has several different programs, and one is asset and income based, and one is not. And there's always a lot of confusion about this. Okay, so SSI, who knows what SSI is? Anybody? Okay, so SSI, first of all, in all of these situations, you have to be determined disabled. And there is a unit in Massachusetts, basically through Mass Health, that they make the determination of disability. You have to not be able to be substantially gainfully employed. This is a Social Security rule. And basically you can't earn more than about $1,100 a month right now. Okay? And this is for anybody. Any age. Doesn't matter. If you have income low income, assets below $2,000, and you're disabled, even if you've never worked and contributed to Social Security, you can receive SSI. Okay? And children under age 18 can receive SSI, but they look to the income and the resources and the assets of the parents to determine whether or not they're low income, low asset. All right? And there's deeming rules, and I'm not going to go into them. All So SSI is available. If you get SSI, if you're eligible for SSI, you're automatically eligible for Mass Health. And that's a lot of the reason why you never want to lose your SSI. Because sometimes it's not about the $720 that the Social Security gives you. It's about the medical benefits that you get through Mass Health. All right? So as long as you're on SSI, you get Mass Health. No, you don't have to file a separate application. All right? But you have to, again, be low asset, low income. It is available under age 18. It's also available over age 18. They'll do a redetermination as an adult after age 18. But again, you can qualify. And there's not the deeming rules after age 18. Okay. Then there's SSDI, which is Social Security Disability Insurance. Again, anybody can get that. That's what we get if we've worked and we've contributed to the Social Security system and we become disabled. It's our Social Security benefit. We've paid into the system and we get it. Your children can also get it if you're retired or if you've passed away. That is not income-based or asset-based. You could win the lottery tomorrow and still get SSDI. All right? So you can have any amount of money that you want and you get SSDI. All right? Often with that you will see the terms Social Security disabled adult child. So that's a form of the SSDI benefit. And that's what most, unless they've worked and contributed to the system, a lot of people that are disabled, that have been disabled from a younger age and grown, they're going to get the disabled adult child. You can actually get all three. You can get your own SSDI benefit based on your own work history. So let's say your child. They've worked, they've contributed to the system, they get SSDI because they're disabled under that. Then they also have disabled adult child because they get that off their parents' Social Security work history. And then SSI if they're low income and low asset. All right? So you can actually get all three. If you have assets, or if the child has assets of more than $2,000, they're going to lose the SSI. All right? And what happens if you lose SSI?
That's annual.
2,000, no, it's assets. So 2,000 in money, countable assets. That's not income. All right? So, and I'll explain the difference from that in a minute. But if you go over $2,000, what do you lose if you're on SSI? What's the big thing you really lose? The Mass Health, right? So that's the key. You stay below the $2,000.
So you say assets, is that just money, or say you own a car and that's it, you lose it?
A car is not countable, so they don't make it easy. So assets are countable assets. So it's the things that they count. And it's basically what they say you can contribute to your living, okay? Or what you can contribute to your care. Not countable is a car. A house, if you live in it, your home is not countable. There are some other things you can pre-arrange a burial, and that's not countable. You can have some limited funds. There's limited things in there you can
College
have.
fund?
Not college is countable. Okay. But again, it's not your money. It's their money.
Right.
Okay. It's the child's money. It's the disabled person's money. All right. The $2,000 is it. It can never go above $2,000. You go to 2001, technically you've lost your benefit. All right. You lose the SSI, you lose the Mass Health. All right. But you can apply for Mass Health independently. So you don't have to just apply for Mass Health through Social Security. You can apply separately, and that's only income-based, as long as you live in the community. If they go into a residential placement, then they start looking at the assets. All right? So if they live in the community, they're low income, they can continue to get Mass Health. If they go into any type of a residential placement, then they're going to have to again be below 2,000. All right? Follow? All right? So for a lot of people, the criteria is not the SSI itself. It's $720 a month, but it's reduced for things like if they live in the household of another. It can be reduced based on money that they might work and earn. You know, they might have some small earnings. So there's different things that it's reduced for. So sometimes it's not about that money. It's about the Mass Health benefits. All right. Does that answer your question about the 2,000?
I think so.
Okay. And so what happens a lot for people who have younger children or family members that are getting SSI is there's this need to constantly spend money. And that you really, that's what you can spend it all day long. Can't give it away, but you can spend it, and you can, as long as it's for the child or the disabled person. So if there's things they need, you just keep spending to keep that below the $2,000. Okay, because the accumulation, because sometimes if they're getting $720 a month, say, and they're living with you, and you're buying the food, and you're, paying the car insurance, and you're doing all these other things, that money, after 3 months, you're going to be above $2,000. So you want to make sure that you're spending their money and it's not building up. And this becomes a problem, especially when younger people are still living at home, because the natural instinct is you just pay for everything together, right? And then their money just sits in the bank and grows and grows and grows. But you're going to get penalized by doing that in terms of you could lose your benefits, all right? SSDI and SSDAC, Social Security Disabled Adult Child, no income and asset limit. You do not automatically get Mass Health with that. You get Medicare after 2 years. Okay. So I love, well, I probably should say this on TV. I'm not going to say it. So you get Medicare after 2 years, and then you can actually have SSI, SSDI, or SSDAC, Medicare, and Mass Health. Okay, so you can have all of them. There's no restriction as to how many you can have, all right? And each one is going to pay different things. So Medicare, of course, is going to be the payer of first resort, and then the co-pays and all those other things will get picked up by Mass Health, all right? And Medicare, again, no asset or income-based program there. It just simply is. If you're eligible for SSDI or DAC, you get Medicare. But you have to be disabled for 2 years before you get it. And they basically come out of two different pots. They're two different funding pots with the government. And that's why they're linked. SSI is linked to Mass Health. It's more of a welfare-based program. And Medicare is linked to SSDI. It's more of what we've contributed into the Social Security system. The working people have contributed to Social Security. All right? So, questions about that?
What if the person was disabled before, for their whole life? How can they then just be disabled for 2 years?
No, you don't get Medicare until they determine you're disabled for 2 years. So the disability determination is something that's made by the agency, the state agency. And it's 2 years after they make that determination as to when it is. Now, because of the way the applications are filed, it can actually be that you become eligible and then you're determined disabled, have been for, the onset has been 2 years prior, but that's kind of beyond the scope, okay? But generally speaking, after they determine you're disabled and they institute the benefit, then 2 years later you get Medicare. That's how it usually works, all right? So that's Social Security, okay? You will want to, if you're dealing with the Social Security agency with your child, you'll want to make sure you're going to have to take them with you, and they're going to have to make you their authorized rep and or their rep payee in order to receive the funds on their behalf. Okay? Social Security is not as flexible as the doctors, and they're not going to talk to you. And I have marched in with many a client with very marginal confidence and been able to talk to Social Security because that's what Social Security is used to. They want to see the client. Okay? Or in my case, the client, but in your case, you take the child with you. Yes, you have permission to talk to my mother or my father, and yes, I'll sign the papers. Okay? If they're under a guardianship or a conservatorship, then in fact that you would go in with that documentation. All right, and then you would have the ability to do that, to become their rep payee and to become their authorized rep in terms of doing things with them. All right. You have to report to Social Security every year what you've done with their money. They do send you out a form and require that you report how the money's been spent. They just do that to ensure, I don't know really how much oversight there really is on that, but they do send it to you every year and you should fill it out. and send it back, just saying how you've spent the money. So again, if you're the rep payee and you're doing that, you want to keep good records, because it'll just make it easier for you every year. I don't like when you do your tax return, if you've got everything laid out what you spent the money on, it's just that much easier. Which is, to me, always a hard concept, because, I mean, I've got kids. Your kids are your kids. You don't keep track of how much you spent at, you know, at Bob's or whatever on their stuff. You just spend the money and that's it, you know, and you just don't even think about it. But when it comes to dealing with all of these agencies, especially once they're over age 18, you've got to keep track of all the money and stuff. Same thing if they're under a conservatorship. In other words, if the court has appointed you to take care of their legal and financial affairs, then you've got to report to the court. You've got to do an accounting, and you've got to report to the court as to how their money's been spent. So you gotta. It's just better to set yourself up good from the beginning, so that you don't have to go back and scramble later on. Create a little subfolder for all their stuff and put it in there, and do the bookkeeping at the end of the year or whatever. All right. Mass Health. Everybody somewhat familiar with Mass Health? Okay, so it's a medical insurance program. If you're in the community, no asset base, so those called the countable assets don't count. When you go into residential, you can have $2,000. An individual can have $2,000 in countable assets. Non-countable assets are typically your car, your house, burial account, certain life insurance policies, and those types of things. And then, again, you get it if you get SSI, but you don't have to. You can get it independently as well. All right. Mass Health, in terms of what it pays for in terms of residential programs, is very limited. It basically pays for nursing homes. That's really what it pays for. It's not going to pay for any more independent type of a living arrangement. It doesn't even pay for an assisted living. So in terms of, we think of, you know, an assisted living where somebody lives in a place where they have a little bit of help, but not a lot, Mass Health does not pay for that. There is another program called Group Adult Foster Care, and this would certainly be maybe when your children are a lot older, but there are some programs for low income that Group Adult Foster Care, where they will pay for some assisted living type arrangements. Okay? Residential funding is always an issue in terms of if you need to have a place outside of your home, or what's going to happen when you're not here anymore to take care of them, and where to do with that. It's always an issue, and it always involves, at least in my experience, it involves a negotiation. And what you're trying to do is to get everybody who can provide something to throw it into the pot, so that you can fully fund the most flexible and most independent placement you can. All right? So DMR might provide something, DDS might provide something, you might provide something. You know, and, you know, some separate side programs. There's a lot of community-based programs that might put money in. Charities might put some money in. So depending on the nature of the disability, sometimes the charitable organizations will contribute money. Cerebral palsy actually contributes a lot towards in-home care, you know, in terms of paying for PCAs or something to come in. So there are programs where you can be paid to take care of the person. I'm just going to keep saying the child, but in terms of you can get paid as a PCA. So there are some programs out there that will do that. So there's all these different things. Until you're faced with that decision, you can't find the right fit. Unfortunately, there's no easy way to do that in advance, because everything changes. Okay? But it really is about a staggering. It's about, you know, pulling a little money here and a little money here and a little money here, and maybe they share a residence with somebody else, and they you know, group all the funding together. So, you know, your child gets 12 hours and another person gets 8 hours and another person gets 4 hours, and before you know it, you've got 24 hours worth of care, if my math is right. Right? So that might be how you do it too. So one aid comes in under one person's benefit, another comes in, but ultimately then there's somebody there all the time to oversee things. Placements in terms of where they live, the homes, the group homes, you know, if it's a group home type situation, or where they live, that's always an issue too. You know, where are they going to, what residential place are they going to live at? Some people leave their homes for their child to live in, and then so the home is in trust, and that home stays there, or an apartment or a condo or something along those lines, and that home is there. So the person has a physical place to live, and then we have to again pull in all these sources to provide funding to get in-home care because the person can't live completely on their own. You know, so, I mean, sometimes it can. Sometimes just having a place to live is good enough. But sometimes you need people to come in, make sure the meals are prepared and things like that, depending on the level of functioning, okay? But that's always the hardest part. And I think the hardest decision is, you know, pretty much everybody here is pretty young, but what happens when I'm not going to be here anymore? And that is the hardest decision. And the sooner you can think about, you don't want to worry yourself to death about it, but the sooner you start thinking about it, things like making sure that you've gone to an agency and they're aware, they have an open case, makes it easier. So you have they had a file, say, at some point when your child was 2, and it was open. Nobody ever gave you anything because there's no money to give it to you. But now you're not here. Guess what? They have to give it to you. Somebody's going to come up with something. Because now they're faced with, assume there's nobody else to take care of your child. The state can't just say, hey, we're not going to take care of them. We don't care. We don't have the money. They're going to find a way to do that. Okay? So if they are aware that your child is out there, then you're that much better off, okay, in terms of having it, even if you never get anything from them right now. At least then, if something happens to you and your family calls and says, I don't know what to do, and I call them up and I say, oh, no, they were eligible for services 8 years ago. Oh, okay, well, let me look it up, let me find their caseworker, and it just kind of speeds up the process a little bit. It's not perfect. It doesn't always work perfectly, but at least it's a start, okay? So, but that's the hardest part, is the funding of where somebody's going to live when you're gone. And there are things you can do in advance if you have the option to do that. Things like life insurance, having adequate life insurance, setting aside different, putting money away every month or whatever. And I'll talk a little bit how that works. You can't just give it to the child. But, those are some of the different things if you have that option. Not everybody does. Some people don't have the extra money in the budget to do things like that. Sometimes people don't do it early enough. And if you're 70 and thinking about health insurance, your premiums might be way too high, and you can't do that anymore. Your health is not good, and you can't do it anymore. Life insurance is usually a pretty good way of doing that. You pay a premium every month, and then there's a chunk of money there when you're gone. And that's when your child's going to need it the most. Is when you're gone, because you're pretty much going to be doing things most likely while you're here. So it's all very specific to each person, so there's no really one hard and fast rule for anybody. There's nothing that's perfect about any of it, but you just do the best you can do. The other thing that's important, and this is in terms of your own estate plan. So again, now we're just kind of thinking along the lines of, well, you're going to do what you can do during life. You might deal with the guardianship, you might deal with the conservator, you might deal with healthcare proxy, the power of attorney, mass health, social security, all while you're still here. And then depending on what your child might need when you're not here anymore, what are we going to do about that in terms of where's he going to live? How much services? Maybe they don't need a lot of services. Are they going to live with a sibling? What's going to be the plan? And one of the things you should do in your own estate plan, besides nominating a guardian, or to think about, you don't have to do it, but it's always good to think about, is trusts. And that's the best way to ensure that you can leave some of your money to your child who might need it most in a way that will not allow them to lose all of these benefits we've just talked about. And they're called special needs trusts or supplemental needs trusts. All right? And there's basically 2 types. And one is a third party, what we call a third party trust. And that's a trust that you would create. Or anybody could create. The grandparents could create it. Anybody can create it. But it's not created and it's not funded with your child's money. Okay? And that allows you to put all the money you want in that trust. There's no limit. And the money comes out of that trust in a way that supplements the public benefit programs or the charitable programs. So it supplements SSI, it supplements mass health, it supplements DDS funding, DMH funding, cerebral palsy funding, anything that you might get from anybody else. all right? And so it's only if they don't pay for it, then the trust kicks in and pays for it, all right? Many times, most people, what we do is we set them up and they just sit there with $10 in them as long as you're living, and then when you pass on, that's when it gets the money. And a couple of things it does. So one, it supplements, it allows your child or whoever you might be creating it for to continue to maintain all their public benefits, all right? And then it also allows that when that child no longer needs the money, that child's passed on, your money can go to whoever else you want it to go to. It can go to your other children. It can go to your grandchildren. It can go to your next door neighbor. It can go to whoever you want. You don't have to pay the state back for the care they've provided or the funds they've provided to your child, all right? Which is different from a first-party trust or a D4A trust. I don't know if you've ever heard of those, all right? That's created with the child's, that's funded with the child's own money. Now, that has to be created by a parent, a grandparent, a guardian, in Massachusetts it would have to be a conservator, or the court. All right? So those are the only people that can create that trust. But in that trust goes the child's money. Okay? Now you say, well wait a minute, how are they going to have money? They get in a car accident and they get a settlement. Grandma decides she's going to leave them $20,000 because they might want it. $20,000 is going to be how much too much for SSI? $18,000 too much. Just long enough for you to lose the benefits and have to reapply, right? It's not a good situation. Grandma doesn't have a will, and they inherit automatically, okay? So, or they get an inheritance that you had no idea that they would get. This is how these commonly come up. Some sort of litigation, and they are entitled to some sort of an award. Okay, I've had that happen as well, where there's been some sort of litigation involving the child, and then they've gotten money back because there was some of them had issues, had to do with care workers and things like that. But anyway, so they've had a lump sum of money. Again, what does that do? It doesn't help them. It hurts them. They get $60,000. Again, all these things we've tried all this time to put together. Convince DDS they have to kick in, convince, Mass Health and SSI and all these other things, and then you lose it until you spend down below the money again. So the D4A Trust is a great thing to have just kind of in waiting. So what I usually encourage parents to do is if you're doing the third party to do it, go ahead and just do the D4A Trust. You may never need it, and it has to be funded before they reach age 65. But you may never need it. But remember, it can only be created by a parent, a grandparent, a conservator, or the court. So if you or your parents create it, it's simple. It's just another piece of paper to sign when you do your own estate plan. If you have to go through court, or you have to get a conservatorship, it's a more complicated, more costly approach to doing that. Okay? So we can actually go in and have the court create it. So I ask the judge to make the trust. And that's what happens. And so but then we're dealing with grandma left him $20,000 and now we got to get rid of it really quick. And how are we going to do that? We have to create this trust. We have to ask the judge to do it, assuming you aren't here to sign it or your grandparents aren't here. So then you're just faced with this little lump sum of money that's just a pain in the neck, frankly. And you got to get rid of it. So it's either a conservatorship, which is often hard to get out of once you get into it, or you ask the court to create it. Though that particular trust is a creature, or it's a creation of the federal rules, and Social Security has a long list of regulations and POMs about those trusts. But the minute you do it, and they see a trust, they try to terminate benefits. So oftentimes you're going to be faced with a Social Security appeal. So if you have to fund it, they may also have to defend it. All right, now, if you create it when you do your own estate plan, it just sits there with $1 in it. We don't put anything in it, and it just sits there and it just waits. And then if it's ever needed, again, just know that you may have to defend it with Social Security as well. Okay.
So I have a question. I've already set up. I have a special needs trust. two of my kids in a special needs trust for one of them. It's not funded until we die. It's not funded by specific life insurance, which I've thought about doing, but it's hard to get life insurance as you get older.
Yeah.
It's very costly. So you're saying you have that for when you die, but you just create this, you just call it this first party trust, just to sit there? Like, I've never heard of this one before, that it just sits there in case they ever get inheritance or.
That's the D4A, that's the first party trust.
Right.
Okay. Yes, so that can just sit there. You don't have to do it, but sometimes it's helpful to have it. And if you're doing your own estate plan, it shouldn't be costing you that much more money to do it. And it's going to certainly cost you a lot less than if you have to get court approval or have a conservatorship.
And you don't fund it, it just sits there.
No, because it's never going to hold your money. It's only going to hold the disabled person's money. Okay?
So the $2,000, just going back to that, so say my son has a bank account, and he gets money, holidays and birthday, and I've always kept $2,000, under $2,000 in that account. Now, that $2,000, can you spend that money on anything, or it has to be?
The $2,000 that belongs to your child,
Yeah.
as long as it's for your child.
Okay, so
Yeah.
I heard it, what, it can't be on like clothing or necessities.
If you can't, so Social Security, SSI is to cover necessities, but, so how do I explain this? Let me think about this for a minute.
So right now, he doesn't get any of that. I can
Okay.
use the money for
So,
whatever.
so let me flip it for another way. Usually the way that becomes an issue. So here's $2,000, you can spend it on anything. All right. The way it works the other way is, say you had a trust. Say you have that special needs trust set up. And he's now receiving SSI. SSI is the $700 and something that they give you a month is to pay for your food and your shelter. So the trust can't pay for his food and shelter. Because if it pays for his food and shelter, then they're going to reduce to $720. All right? So that's kind of where that really comes in. It's not what you spend his money on, it's what everybody else, what the other money gets spent on. If he's not on SSI, if he's on SSDI or SSDAC, you can spend it on anything. All right? Used to be food, clothing, and shelter. So you used to not even be able to buy clothing. But now you can buy clothes, but no food, no shelter. And along the same lines, you have to be very careful because if say you're paying for a trip and you want to go to Disney and that trust is going to pay for that, it really technically can't pay for the hotel room because that's shelter. See? So the administration of the trust is difficult, but you get the gist of it after you get to know the programs and you become more comfortable with it. But oftentimes it's not going to be you that's doing that. It's going to be somebody else. Because as long as you're here, unless the money's funded with somebody else's money. I mean, it could be that, your parents decide to leave money to their grandchildren. The best way to do that is to have your child who has special needs, have their money go into a trust, and then it's set aside for them. Even if it comes from the grandparents, it can go there. So, and then you might be administering it, right? Because then you might be deciding what to spend the money on. Okay. So that's the issue. The administration of the special needs trust is the most. That's where people run into the most trouble. It's not the creation of the document. The document's pretty straightforward. And then it's the way you pull the money out that becomes a problem. So if DDS is paying for a PCA and they're going to give you, 10 hours, then you have to make sure that you're only paying for 14 hours. Because if you're paying for 10 hours, then you're cutting into what DDS is giving you. Okay? So it's all very specific. Go ahead.
So, do you recommend having both types of trusts?
I have started doing that, yes, because I have seen too many people have too many really good plans in place, only to be losing them because of some. And believe me, it's never $1 million. It's $20,000. It's $30,000. It's just enough to make life really difficult.
Because I know my child's a beneficiary on my mother's, in my mother's will. And so, trying to figure out where she should direct that to.
So the better thing to do there would be to have it be in a third-party trust, And again, anybody can create that third-party trust. It does not have to be created by the person who's putting the money in. They can, but they don't have to. Because then what happens is when your child is gone, that money can go wherever you want it. So I should say, and I probably didn't say this yet, in the first-party trust, whatever money's left in that trust when your child passes away, that money goes back to the state. So I probably missed that piece. All right? So that goes back to the state. All right? But again, that's the child's own money. But the thing about it is, two things are still better about that. One is that $20,000 is going to make them lose all these benefits that you've put in place. And then you have to go reapply for everything. And then two, if there's nothing left in the trust, then the state gets nothing. So you spend that money first. And then when that money's gone, then the trust is just there too, still waiting. And then the third party trust, that money in that trust can go to whoever you want it to. Okay? So that one, because that's with everybody else's money. And there's no obligation that you have pay that to the state.
So grandparents and parents and whatever should be leaving, if they're leaving it to the child, they should be leaving it in the name of the special needs.
It's better to do that, yes. Yeah, if there's any chance that you think, even if your child's not legally disabled, if there's any chance, and again, you don't have to be legally disabled, in terms of, you don't have to have this disability determination or anything like that. But if you think that they're not going to be able to manage the money on their own, then the better thing to do is to put it in that type of a trust. And if they're not on any public benefit programs, then the trustee can dole out the money for anything. All right? But the child doesn't control the money. And if they need public benefits, they're not going to lose those public benefits because of the money that they're receiving. All right? So, and I have found, a lot of times you have options if you able. Not everybody can do this. I mean, it's not feasible for a lot. A lot of times, just financially, you can't put a lot of money in these trusts, or there's not a lot there. There's certainly many times there's not enough to provide for a child for the rest of their life. But if there's a little bit there, then it is easier to convince some of the better residential placements to take them. Because then we get DDS to put more money in, DMR to put more money in. We say, hey, look, we've got something we can bring to the table, and you guys help us add to it. And that sometimes will help. And a lot of times we put residences in there. So again, maybe somebody buys a condo, or they put a condo or an apartment or something. And then if the person can no longer live independently in that apartment, in that condo, or whatever it might be, then we can sell it. The money stays in the trust and can be used for other things. Okay? So it is good, even if you don't think of it in terms of, there's no disability determination yet, it's still a good idea to have it in place. And how you go about funding it, maybe you don't know that now. Maybe you won't know that for 20 years. You've got to balance children, retirement, all of these other things that we have to think about just day to day that we have to use our money for. You may not know that now. But when you're gone someday, maybe your house will get sold and your proceeds will be split. Some people think, well, I'll just disinherit the child and I'll give it all to a brother or sister, and a brother or sister will take care of her or him. You can't do that. Brother or sister gets a divorce. Brother or sister gets in a car wreck and somebody sues them. Brother or sister passes away and is married with his own kids. Then his money goes there. It doesn't go to his sister or her brother. So that's not a good option, and that I've seen that a lot. And there's no legal obligation. If you leave all of your money to one child, there's no to a child who you think is going to take care of your special needs child. There's no legal obligation to do that. And sometimes, even though they want to do it, they can't. They might have their own health issues. As they might be 60 and have their own health issues that they can't do that. They have to think about the fact that they can't give the money anymore to their brother or sister. So, all of these things come in. So the better thing to do is to set up the trusts and have them there. Whatever ends up in there, ends up in there. Whatever their share might be. It might be $20,000. It might be, $200,000. We don't know what it is. If there's life insurance, great. The best thing you can, if you can plan ahead, it's great. You know, that's an investment advisor, life insurance advisor type of conversation, right? If you have a retirement plan, whatever's left is going to, you know, say when you're gone, it's going to split between your 4 kids. You can put their fourth into their trust. You don't know what that might be now. And you got enough to think about, I'm sure. But at least if you've got the bones in place, then you've got the plan there and you're ready to go with it, whatever it might be. So, and it is kind of more than just the paperwork. It's more than just the documents. It's also the conversations with the life insurance people, investment advisors, in terms of if you want to think that far in advance about what you're going to do in the future. But again, keep in mind, even if you have those trusts in place, doesn't mean if they never get a public benefit, they can still have the money for whatever they want. It's up to the trustee to give it to them.
Doesn't the first person trust also, protect the parents or grandparents that would be contributing to that trust in the event that they need to go into a hospitalization or a nursing home, that their house and assets would not be recovered by the state, that those assets would actually be
yeah, so if mom or dad themselves is going into a nursing home, then mom or dad can contribute all of their assets. So basically, if you yourself go into a nursing home, I go into a nursing home and I'm married, I can keep about $120,000. If I'm single, I can keep about $2,000. And then after that, the state will pay for my nursing home care. And the $2,000 is countable assets. It doesn't include your house, but the reality of it is ultimately they do end up taking your house if you're single. If you're married, you don't. But if you have a disabled child, then you can put all of your money into the trust for the disabled child and go right into the nursing home, and all of your money that you have will be there for your disabled child.
In that de facto
trust. Usually in the D4A Trust.
D4A.
I will tell you though, sometimes the third parties slip through. Sometimes, so the D4A requires the payback when the disabled person passes on. But it depends on the caseworker, and sometimes the money doesn't actually end up getting paid back. Okay, but yes, you can contribute everything, no penalty. So if you're yourself thinking about nursing home care, why not? We're thinking about enough gloom and doom here. We're thinking about going into a nursing home. If we want to give things away to protect them so that our nursing home care can be paid for, my nursing home care can be paid for, I generally have a 5-year penalty period. Okay, I have to give it away now and stay home and healthy for 5 years, unless I have a disabled child. Now, in that case, you have to have a disability determination. Okay, it can't just be a child who has special needs and needs more help. You actually have to have somebody have said that they have to have that disability determination in order to do that. Okay, and grandparents can do it too. Okay, so and that could be and a dependent child as well. So it doesn't even just have to be. It could be a dependent that you care for. So sometimes it could work with siblings and things like that as well, if they're on your income tax return and things like that. So so that yes, that's another way. And having that trust in place already is helpful. Because a lot of times if I'm going into the nursing home, I might not be competent anymore. And then I can't create the trust. And then we have to figure out who's going to create the trust and how are we going to do it. And a lot of times it's another way we go back into court. So the goal is to try to keep the court out of your life as best you can, right? So so if you have these things kind of set up, so that's another way to do it. Yeah.
And to reiterate what you stated earlier is that there's that 5-year grace period that once you acknowledge that assets are going to go into that trust fund, you need to stay healthy for 5 years. If you don't, then the state can still recover.
You have to stay home and healthy. If you give your money away, and you're good, and you yourself, so it's me or you, and we give our money away to anybody other than a disabled child, we have to stay home and healthy for 5 years. If you give it away to a disabled child, you can go into the nursing home tomorrow. No 5 years with a disabled child. Okay? Or into a trust for. Now, you can give it outright to the disabled child. You don't have to put it in a trust and still don't have the 5-year period. But that creates another whole issue, right? Because then they lose their benefits. That's why these trusts are so. But yes, you don't no 5-year period. If it's you giving your money to a disabled child, grandchild, and you can give it outright to them if you want to, or you can put it into a trust. Trust is always the better option. One, because they probably can't, many times they can't manage it. If they're, you know, I mean, there are physical disabilities that cognitively everything's fine, and then they can manage it, but they might have other benefit programs that you don't want them to lose either, and that's where the trust comes in. Now, the D4A Trust can only be funded, that's the first party trust, can only be funded till they're 65. Okay? And then after that, you have to rely on something called a pooled trust. Okay? And that option's available to anybody.
What was that
So,
called?
it's a pooled trust. And that's any age. And what that is it's run by a nonprofit, and you put all the money in one big account, and each person has their own account. And it's for disabled individuals, and then each person has their own account, and they can draw off that money in the same way we've talked about everything else. Not food, not shelter if you're on SSI, those types of things. But that option is available even if you're over age 65. Okay? So that's always an option if somebody's at any age. All right?
So you can't contribute any more to it?
The D4A Trust?
Right.
Yes, after age 65 you're done. You can't put any more in it.
So if
Right.
there was $100 in there, you can't add, but you can say it.
They can stay on it, right. After they reach age 65. Not you, but the disabled
Yeah.
person. Yeah. So whatever's in there is in there usually for 65. And I mean, does it happen? Sure. I mean, I've had parents that were still caring for their disabled children who were 90s, and their disabled children are 70. And then we have the thing. Now here's the other thing. If you don't set these things up, the other thing is, so say you're going into a nursing home and you want to put the money in the D4A Trust, and you don't have your own documents in place, you don't have a power of attorney, and you're not competent anymore, then we have to get a conservatorship for you to put the money in the trust for the child. Okay? So that's why having these things in place really, really saves a lot of money, it saves a lot of aggravation. And then the other thing is, if you don't have the D4A Trust in place, and the court has to establish it, the court also has to approve the transfer into the trust. Because if you're using a conservatorship, you have to go through, if you're in the situation where you have the conservatorship, you can't do anything with the child's money without the court's permission, basically. Okay? So you can spend it on them, but you cannot make any big transfers like into trust and things like that. So you could be facing 2 or 3 court actions, all linked to one transaction, is what I guess I'm saying. Without the proper, which a healthcare proxy and a power of attorney, frankly, are not a lot of money. And nowadays, and thank goodness, the PCPs are getting good about having you do them when you go to the doctor's office. And they're fine. Those documents are perfectly good. You do not have to have a lawyer do them. So the documents that they give you at the doctor's office, the problem that you face when you go into the hospital, they give them to you, you sign them, they scan them, they shred them. And then you have one, but you can't ever get at it to use it again. So you always want to make sure you keep copies of everything. And if you go to the hospital, make sure you don't let them keep everything, because what they're doing these days is scanning and shredding. And so and you need that paper. You have to have originals, or photocopies of originals. Okay. All right. Questions?
Can you
Go ahead.
comment on the ABLE app accounts?
I can, if I can remember. Let's see, my brain. I'm familiar with them. That's where you can keep up to $100,000, and they are not counted. I've done a whole bunch of research on them. I just haven't used them yet.
It's
So
new, right?
it's fairly new, and I'm trying to think if Massachusetts has started them
I
yet.
think they
I
have.
think they just recently started them. And what it is it's non-countable for Social Security, I think it is. But that doesn't necessarily mean it's non-countable for everything. All right.
I thought it was somehow related to education too, or there was some connection to.
Yeah, and you know what? I looked at them a lot. What happened about a year ago, I really looked at them closely. I haven't used them a lot. I am familiar with them being non-countable. And then because they weren't implementing them, I just kind of lost track of them. If you leave me your email, I can send you some info, or I can send everybody a link on it or whatever. I mean, they're out there. They're going to be an option, maybe. There's a lot of bugs still. There's a lot of things that that have to be figured out. But there's only certain. They have to have certain institutions are setting them up. I think is the issue. Each state has to implement them in place. But and I'm not sure that it just has to be for education. I have to look at that and see. Okay, but it basically creates and allows some money to be non-countable.
And I think there's some relationship to the 529. So if you had set up a 529 when your child was born, and it turns out
You
that
probably
you're not
can
use that money
yeah.
instead of being
Yeah.
penalized,
Yeah.
I think you can transfer
You
that money.
probably can
It's
transfer
there, and
over
you
to
can
that.
use it for
That would
other
be good.
things, like
Yeah.
it could be for what do you call it? You know, other types of training, like
Yeah,
job training,
vocational
or
training and things.
vocational
Yeah.
training. That's what
I
I'm
think,
saying.
and I think it is, yeah, and I think you can transfer it over there, but I don't think, and I'm not sure about this, I could be wrong. I don't think you have to only use it for educational. But I have to check on
I
it.
think you're right, but I think that the benefit is that you can.
Yeah,
And because otherwise, if you have a 529 and you can't use it, and you don't have another child,
right.
Yeah.
you know, you're penalized.
Yeah, because you get penalized for doing that. Yeah. But I mean, I can look at that and say, you know, it's funny because I looked at that and I should have looked at it before I came tonight. But
I
I
was
looked
almost
at
going to
it.
send an email ahead of time and ask if that could be.
Yeah, that would have been good.
Yeah.
But I don't mind saying I don't know something. So
No, it's friendly. We're all learning.
I read about them for a while and I thought, oh, these are a really good thing. And then the last time I looked at them, Massachusetts wasn't doing it yet, and I was like, okay, I'll look at this better when it becomes more relevant. Frankly, I would probably look at it when somebody came into me and said, hey, what do we do about that ABLE account? I'm like, okay, I will figure out how it works. So, and that's usually, sometimes that's the learning process with this stuff too. It's like even just like staggering the benefits and things like that. So, okay. So, I'll make a note. Did you put your name on here?
No, I don't think I've signed it yet.
Okay,
I'll
so
make
let me,
sure.
I'll make a note, I'll send out an email. There is some good literature out there, because I remember reading it. So, I just don't remember what I read. So, all right, questions? Go ahead.
To set up a trust, you have to look a little bit.
Yeah, yeah, and you want to use somebody who's familiar with those types of trusts. You have to be very careful, because if that trust contains the word support, it's countable. Okay? And a lot of times, attorneys that don't practice in this area will just set up one that's trustee discretion for it, because there's tax language out there that says health, education, maintenance, and support. And that's what they call an ascertainable standard. And that's what a lot of people put in their trust. If it contains health, education, maintenance, and support, then it's a countable trust for all of these programs, because they provide health, maintenance, and support. Okay? So you have to be very careful about the language that goes into those trusts. Yeah. And then the second part that's hard about those trusts is picking your trustee. Who's going to administer that trust? Because that's really where the rubber meets the road, is how that money comes out of those trusts. And I have had professional banks, professional fiduciaries doing it all wrong. Because you have to use people that are familiar with that. I mean, Section 8 housing is always an option. That has its own set of rules. I mean, every particular little program has its own set of rules as to how you can... the trust itself will protect all those programs. At least today it does. And then, but then you have to know what the beneficiary is receiving and make sure that you don't run afoul of all of these different rules at the same time. Okay. Because Section 8's always an option. And they actually treat the income as being countable. There's a case out there. But anyway, so you have to kind of, the administration is what's tough. You had a question?
I know it probably varies, but could you give a ballpark on what it would cost to have a special needs trust running?
That's tough. No, I probably couldn't. I mean, if I sat down with somebody one-on-one, but what I tell you is going to be different when another attorney might tell you. So, my approach...
To that degree. I'm
Huh?
sorry, it varies to that degree.
It does vary to that.
Because I mean, it wouldn't be like a ballpark. Wow.
No, it depends on where you go. It depends on where you go and who you see. Yeah, it varies greatly. Yes.
I know when I did it, we sat down and we did, I mean,
Yeah, no, but, no, well,
It's not a couple $100.
no, it isn't gonna be, no matter where you, it's not gonna be. But you're right, doing it as a package is usually the best way. Because you're gonna update your will for the guardianship, you're gonna update your own healthcare proxy and power of attorney, your own powers of attorney for the reasons that you were speaking about in terms of if you wanna be able to put money in a trust for your child, if you go to a nursing home, should contain certain things like gift-giving powers. If it doesn't, then you can't put the money in the trust for your child, because effectively you're making a gift. If you're not competent to do it anymore, your power of attorney, you have to use that document to put it in there. So it generally does include things like a healthcare proxy, power of attorney, your own will, and the trusts. Okay, and those are the things that you typically would do as part of one of those things. Do you have to? No, you don't have to. If your will is good and your healthcare proxy and your power of attorney are good, I'm not going to tell you to do a new one just because you're sitting there, but, you know, oftentimes people do because they haven't looked at it for a while. And you want to make sure that the money gets into the right trust, too. Because a lot of people have wills, oh, I give everything to my husband, and if he's not living it equally to my kids. Well, that's not going to work if you've got one of these trusts. It's got to be, I give everything to my husband equally to my kids, but if my son, you know, Stephen is alive, his share goes to his Stephen's trust. You know, so you gotta kind of do it a different way. So, but I can tell you that most times it's going to be a lot less expensive than a conservatorship or guardianship and dealing with the courts. So, if you can put it in place, then that's the way. If you just bring a child in to do their own healthcare proxy and power of attorney, it should be minimal for that. You're probably looking at a few $100s for that. So, but I hate to say that, especially on TV.
What happens if you have that child that, like, knows is gonna need this or not need this, and you put this into place, and then you find out that that child can hold a job and whatever? Is it there getting rid of it, or?
Oh yeah, you can always change it. So I generally don't recommend that you create. So some of them are, you can create an irrevocable supplemental needs trust, which means that it can never be changed. But generally, there's no need to if it's with your own money. Okay. So yes, you can always make it go away. And then keep in mind if that child is highly functioning, but maybe still needs some guidance, that trustee can, and they're not on any public benefit programs. I mean, ultimately the goal is to protect any potential public benefits. Then the trustee can give them money for anything. So, you know, it might even be that they're going to be able to hold down a job and do all these things, but you wouldn't want to give them $500,000 in cash. Of course, I was a lot of keys. The older I get, the older that age gets. When people say, well, when do you think I should give my child their money? You know, what should they get their inheritance? How old should they be? And the older I get, I'm like, now I'm like at 40. Like, you know, well, maybe when they're 40 they can handle it. You know, I used to be like, 22, that's good enough. You know, but so I mean, I'm talking about just generally just your kids. But so you know, you can always change that. But again, if something happened to you before you changed it, and that is funded, and that child doesn't need any program, that trustee can give that money out for any reason. The D4A Trust is only going to hold that child's own money. So if they're not on public benefits, you don't even have to worry about that. Yeah. So if they don't ever get any benefits, you don't even care. You'll never put the money in there. So if they're out, you know, they're doing their own thing and they're handling their own money and they don't really have any services through Mass Health or anybody else, and they just keep their own money. And that's it.
So, if I have an adult child who I don't want to do, I don't want to take away his rights. I want to just do the healthcare proxy and the power of attorney. Could conceivably he be the trustee of the trust?
No, never can be the trustee because the money that comes out is in the trustee's discretion. And if the trustee has the power, then all of these programs say if he has the power, then that money is available to him completely. So he can never be his own trustee, ever, in this scenario.
Then it would be considered an asset.
It would be, yes, it would be like, well, you have you're the trustee, you have the authority to distribute it out, and you can give it back to yourself. So no, you can never be the trustee. And the trustee, you know, it can be a family member, it can be whoever you think is best. I mean, some people want to use professionals. There are some good people out there that are professionals. There's an attorney that I know who does special needs trust. That's all he does is administer special needs trust. There's a retired judge who's down in, I think he's doing them now, down in Taunton, and he will administer the special needs trust. Or you can use a bank or a trust company, but it also can be a family member who you feel confident can do this and is willing to take it. It's a responsibility, and is willing to take on this responsibility with a little education. Because the education can also be, you know, it may be that the day they become trustee, they don't know how to make distributions. But believe me, after they're doing it for a year, they're going to figure out what they can do. You get a rhythm, and it kind of works. So it doesn't necessarily have to be a professional. But sometimes you want it to be, and some people don't have a choice. It has to be. Because there's nobody to do that. I've had that happen many times, where there's just nobody else, so we have to use a professional trustee. But the professional trustees are going to charge. And so they're going to get a percentage, or they're going to get something, you know, they're going to get paid for their services. So where a family member can be paid for their services, but they don't have to be paid for their services. Isn't it nice what we do to our families? So, but, you know, they can be, but they don't have to be. And you might be that you want them to be, and that's perfectly okay too. But, you know, but that's, you know, the choice of trustee is probably very, as well as the choice of guardian. That's always up to you.
If you choose someone outside of your family that needs to be paid, are they paid out of the trust, or does someone else separately have?
Yeah, they're paid out of the trust. Yeah. Yeah.
And each people would have different rates, or is there a typical?
Usually they all have different rates. Yeah. So like a bank or what have you is going to have its published fee schedule. You know, the couple of people I talked to, they have their fee schedules. They're probably not as much as banks. And again, keep in mind too that there are investment decisions involved. And you can use an investment advisor, so your child, your other child, or your brother, or your mother-in-law can be the trustee. And then you can say, but look, when it comes to investment decisions, go to an investment advisor. Because a lot of times too, the way that this works is whatever's in the trust, you want to invest it in a certain way so that there's enough money to last the rest of their lifetime. That's another whole analysis. And oftentimes, if you got your mother-in-law doing it, it might be that she's like, well, I don't know the difference between a stock and bonds. But with the help of an investment advisor, she can do that. You could also name a family member to serve alongside with a professional trustee, so that the professional trustee may not know your child, but your family member does, and to say, you know what, my brother needs to go to Disney this year, and I want to make sure you make that happen. And then they would say to the trustee, the professional trustee, we need the money for that. And the professional trustee would say, okay, well, we'll do that. Or my brother, we want to buy a house for my brother. He needs to have his own living arrangement. Okay, and then the professional trustee figures out how to provide, and writes the check that has the authority to do it. So you can also put that in there too. So you don't have to necessarily have the family member. They can kind of be in there as a secondary trustee to make personal decisions as to, to have the connection with the child. More questions? Your head spinning? Go ahead.
What would you suggest, setting up, like we were talking about birthday, bank accounts with birthday money and holiday money? When should that switch over to a trust, or is there something else that can go into?
It depends. I mean, actually the ABLE account might be an option for that. I mean, that's one thing to think about, but it depends on how much it is. If it's a lot of money and you think that they're going to be, if they're sitting on $4,000 or $5,000, and I have this happen too. They're sitting on $4,000 or $5,000 and they're going to be going on SSI and they're going to be turning 18. You might want to it's usually just easier to spend it.
Do they look back a certain amount of time to see?
Not if it's spending. If it's giving, they do. But if it's spending, they don't. They're going to ask you what you spent it on.
So like
but
when they turn 18, they can spend $4,000. They're not gonna.
Yeah, and spend it on non-countable stuff. Clothes, maybe if they're, maybe a car. You know, a lot of times, sometimes I have people that have physical disabilities, so they have to be, you know, wheelchair vans and things like that. I mean, they're expensive, and it's a good way to spend. It's a good way to spend extra money without having to do that. Okay, so you just wanna make sure that you're mindful of that limit if that's going to be a problem. It starts by, yeah, because you don't want it to get over that 2,000. And if they do get SSI, now remember, if they're DAC, disabled adult child, or their own SSDI, then you don't have to worry about that $2,000. But if it's going to be SSI, then you do. And remember, Mass Health in the community, only income. It's not asset-based unless you were in a residential placement. Okay? So it may, if you're only going to get Mass Health benefits, it may not matter. Okay? It's only if you're more, so if you're going for the SSI. Okay? So I was telling you about how you have to defend the trust. So in terms of, a lot of times what's happened, I've created these D4A trusts, and Social Security then says, well, we know we created the regs, and we know that it's supposed to not be countable, but we don't understand why, so we have to appeal it, and we go to administrative law judge. So I had a client who we had, and I swear, I think this is why I won the case. We had a trust. We had one of these trusts that she had set up, and her mother had left her a home, and we sold the home, and we put the home, once it's sold, becomes countable money, so we had to put it in one of these trusts. And Social Security said, no, we think it's countable, and she should lose all of her benefits. And she was going to lose not only her Social Security benefits, she was going to lose some DMR benefits, and I'm sorry, some DMH benefits, and some different things like that. So we fought it. And we get before, she wanted to go to court. This was her day in the sun. She was going to go to court, and we were going to win this case. So we go into the courtroom, and judge listens to my whole spiel as to why the thing is not countable. And then the judge says to her, do you have any questions for me? And she says, yes, Your Honor, I do. And the judge says, okay, what's your question? Do you know Judge Judy? So it was just so innocent. So I was like, and the judge just kind of said, no, I don't know her. Should I? She said, oh yes, she's pretty good. She's on TV. I mean, she went through the whole thing about the show. But that was why she wanted her day in court, because she thought she was going to meet Judge Judy. She was so cute. So anyway, and I always think that probably that's the reason that it went through as easy as it did, because she was just so likable. So anyway, so I leave you with that. So you never know. All the rules and the regulations of the world don't matter. If you've got a really nice kid, you're going to go far. So, all right. Questions, comments?
Going back to healthcare, with the Affordable Care Act, most children and students are under their parents' health plans, right? Mm-hmm. So at the age of 18, they're eligible for Mass Health and Medicare.
Well, they would probably be under. Are you still under their mom and dad's health insurance?
Well, so for instance, my daughter is 17, and she's under my plan. We have a Mass Health as a supplemental plan.
Okay.
She'll turn 18 next August, and at that point, am I still liable for covering her under the Affordable Care Act, or will that go directly to under?
I think you could keep her till she's 26. I'm not sure you have to keep her.
No, I understand, but the difference is out-of-pocket expenses for myself versus something straight through Medicare or Mass Health.
So Medicare, is she getting Medicare now?
She's not.
Okay, so she would have to be Medicare eligible. So through SSDI or Disabled Adult Child program, and be disabled for 2 years to be under Medicare. And then you could have the Medicare and the Mass Health. Always never give up Mass Health, because that's going to be the payer of last resort, and that's going to pick up everything. So, but sometimes you don't want it to be. I don't know if you have to keep her after she's 18. You may want to, because you may have more options than what she would get just through the Mass Health program. But if she's on your health insurance and on Mass Health, and she could potentially be on Medicare, it depends on those circumstances, then she could have all three. Yeah. Yeah, and in my opinion, well, the Medicare, once you get it, you're going to keep it. And you want to keep the Mass Health, because the Mass Health is going to supplement, because Medicare is going to pay 80%. And so the Mass Health will pick up the extra 20%. But if you have your health insurance and Mass Health, you may still want to keep her, depending on the financial logistics of it all. You may still want to keep her because you might get better care if you keep her. Yeah, on that, just depending on what the situation is. Yeah. But I don't think you have to keep her. I have to look at that. I don't think you have to keep her till she's 26. If she has Mass Health, because she has creditable insurance if she's got Mass Health. So you know how we have to all be insured. We have to have health insurance.
Yeah. Okay.
So-
Maybe my question is more geared towards Mass Health in her car.
She's on it now, right?
She is as a supplemental.
Do they have to take her as a regular person?
Yeah.
If they determine that she's disabled, yes. Yes, yes. If she's on it now, then they probably would keep her on, yes. Well, you know, I'm not sure, because I've never really known, I mean, Mass Health is always gonna supplement what everybody else gets. Do you have the premium that you pay for that? For the Mass Health? Then yeah, you're probably gonna reapply and try to get, is it through the connector or was it Mass Health?
Straight from Mass Health.
Okay, and so you have a deductible or a monthly premium or something? Yeah, so you may want to reapply based on her income and assets when she's no longer dependent on us. Yeah. Yeah. And then it may be that there is no more monthly premium or deductible. Yeah. Yeah, they've got so many different programs now in terms of, in terms of what they pay premiums for, and then some are through the connector and all these other different, the other different things. So, but yes, to the extent you can get her fully on a Mass Health program, I would do that. Yeah, and without a premium, especially. Yeah.
Now, given if she goes under an SSI and she can only have that $2,000 is there a program to put money aside, like an HSA account for spending on medical things that may come about? If she gets $700 whatever dollars a month.
And I think there is a small HSA account that Social Security allows you to have. I just don't remember what the amount is on it. Similar to that, that's for some medicals, yeah. I have to look it up, because that's not one that I deal with on an everyday basis. But if I remember right, there's a small cycle you can keep for that, like that HSA. I don't know that it's actually technically an HSA, but it's set aside for